So has a dangerous precedent now been set by releasing gang rape and murder lifers? Who is to blame here? The government or the Supreme Judiciary of this country? Has the urgency that was shown after the Nirbhaya case involving such cases completely been lost? Should gang rape convicts be jailed for life, i.e. life? Has injustice at the end of the day been done to Bilkis Bano? That's the story we are going to track. Pinky Anand, Senior Advocate, former Additional Solicitor General of the country, joins me. Siddharth Luthra, Senior Advocate, Supreme Court, also a former ASG. Aman Lekhi, Senior Advocate and another former ASG. And Vrinda Grover, Advocate, Supreme Court, Senior Advocate, who's appeared in several such cases. Let's come to you first, Vrinda Grover, because in a way, the Gujarat government will say it's the Supreme Court which told us to look and review this case. They have spent 14 years in jail and under the CRPC they are entitled to a review. Therefore, why blame us? If anything, blame our judicial system that allows people to walk free after 14 years.
Radeep, the judicial system does not allow anyone to walk out of jail. There is a law which is in Chapter 32 of the Code of Criminal Procedure. There is remission policies which are under the state government. There are advisory boards under state government which determine which of the prisoners will be allowed the largest of remission, and there are a set of criteria, and most remission policies also prescribe which crimes are so heinous that under no circumstances will you be considered eligible for remission. As I understand it, there is a 1992 State of Gujarat policy on remission, which is not available in the public domain. At least I have not been able to read it. The law is that the remission policy at the time of conviction will apply. The 1992 Gujarat state policy, to the best of my knowledge, was scrapped only in 2013. The conviction takes place in the Bombay court. Let us remember, the Supreme Court had actually transferred the trial because it appeared that there was no prospect of a free and fair trial in the state of Gujarat at the time. The conviction takes place in Bombay in 2008, and hence the 1992 policy will apply. What is the state government? Any convict will obviously want to be released. That's besides the point. They go to the court says go to the state of Gujarat. Please remember here, it is not only the state of Gujarat. This case was investigated by the CBI. The law is very clear. Section 435 Code of Criminal Procedure says, if a matter is investigated by the CBI, and I'll read from it, it says the state government will remit or commute a sentence and will not exercise this power except after consultation with the central government. So this decision to release them on remission after 14 years, men who in international law would be arraigned for and they are convicted for crimes against humanity, this is a decision that has been taken by the state of Gujarat after consultation with the central government, which by its policy says rape and gang rape accused are not eligible. This is gang rape and murder.
Okay.
And here I would want to point out, please, this is not that the state's policy towards gang rape has changed or murder lifers has changed. I am not going to decontextualize this. This is signaling a majoritarian state's impunity for certain accused, where the victims are defined and we are defined by certain religious minority victims. This is not a general statement to be made.
Okay,
and the central government is complicit in this decision.
Let's one by one look at the law, because this is a very complicated decision in a way that has been taken that can have huge ramifications. You know, Pinky Anand, the center, according to Vrinda Grover, was consulted as per the law. What the center, interestingly, the Home Ministry has laid down that persons convicted for offences who do not qualify for special remission include dowry death, offence of rape and human trafficking. If I am guilty of rape and human trafficking, then I do not get the benefit of remission. This is as per the June 13, 2022 Home Ministry guideline. And yet this has been flouted. The Supreme Court passes the buck on to the states, and the state government's committee is giving remission in a case of a gang rape, of a woman gang rape, and the people convicted for it, and murder, including that of her 3.5-year-old child whose head was banged and was killed in front of her eyes. Is this a fit case for remission, ma'am?
Rajdeep, I don't know what your real question is. It seems to be a dramatization of sorts. But no, if you look at the law
Yes.
and the CRPC and the Supreme Court judgments, right from Ratan Singh onwards, where it is ultimately a decided issue that the courts have nothing to do with remission. It is the state's policy. And where a matter is of Gujarat, it would be decided by the Gujarat state. The Gujarat state decides the matter in accordance with section 433 and 433A. And that is the decision that they decide to remit after 15 years of sentence based upon the criteria as laid down in their policy. So, I mean, where is the question of dramatizing it to the extent of saying and signifying it as a death signal for some other situations or similar situations? This is case by case. In Radheshyam's case, the Supreme Court asked the Gujarat government to consider it. It was considered. Gujarat government opines itself on remission and releases the convicts. This is the position as it stands.
No,
both on law
that's
as
2
well
points,
as
ma'am. I just want to ask you 2 points. One, are you saying that the Supreme Court has no overriding powers? If you recall, the Gujarat High Court had rejected the plea of Radheshyam, who wanted remission of sentence, saying we are not going to do it. Then Radheshyam goes to the Supreme Court, and the Supreme Court says we'll allow the Gujarat government to review it. So, could the Supreme Court, ma'am, in your view, have had overriding powers and said this is a heinous, serious crime, we are not going to allow remission? Could they have said that, yes or no?
I believe not. I believe not. I believe the Supreme Court is bound by its earlier judgments as much as Ratan Singh and the entire series. And as Vrinda rightly said, it is as per the statute as prescribed.
Yes.
So the question is, the statute itself gives the part of the state government in this particular case, which the state government is exercised. So the overriding powers of Supreme Court cannot come in to say you can't do it. It can tell the government to consider it, can tell the government to review it, but it cannot tell the government you either grant remission or you don't grant remission. It is clearly a matter of state policy until such time as the law stands.
But where does that then leave these guidelines that the Home Ministry has put in place, saying there are certain crimes where you cannot have remission? So within a year of that, you got this case. Now you're saying it's case by case, but this will be used, ma'am, as a precedent tomorrow by other state governments and, dare I say, by other courts. Doesn't that worry you that even a gang rape and a murder of this heinous kind will now become a precedent?
I'm afraid, Rajdeep, that wouldn't be correct. You can't say it will be a precedent for any state. Every state has its own policies and will exercise them in accordance with their policy. So if a state, for example, has a policy that it will not be granted in case of gang rape, and the policy, incidentally, Rajdeep, as you were quoting, you're talking about the centre's policy of June 2022. That is not the policy in any case that would govern. The policy which clearly the Supreme Court has laid down is a policy that will govern the accused at the time of conviction and not now. So in any case, you can't bring in this centre policy to say that that is what would govern. You are right. We need to have this message constantly that you cannot have any disregard for women. You can't say this will be a precedent for any other state. It is an individual state's policies as they determine it and they exercise it. And the Supreme Court asked the government to consider it. It's not as if it came out of the blue. Right. It is on Radheshyam's petition that this entire matter went to Gujarat for consideration under the 1992 policy, which is a prevalent policy which is relevant.
So you're saying the Supreme Court had no option. In your view, Supreme Court had no option.
Yes.
Interesting. Okay, that's one viewpoint. Siddharth Luthra, you agree with that? Did the Supreme Court make the initial, in a sense, some would say, mistake by virtually saying, look, we believe that under Criminal Procedure Code, they've been in jail for 15 or 14 years. Now it's up to the state government. Should the Supreme Court have, in a way, had overriding powers or at least sent out a stronger message that given the nature of the case, you've got to be more careful?
Rajiv, the issue is this. The Supreme Court relies upon the Constitution Bench decision in Sriharan's case, which lays down the parameters. It takes a certain view and remands it back to Gujarat. At this point, the field is open for Gujarat or any state to act in terms of its prevalent policy. Brinda has said we've not seen the 92 policy. Frankly, neither have I, though it's mentioned in the Supreme Court judgment. The 2014 Gujarat government policy takes a different view, but because the conviction took place prior to that, the prevalent policy will be in vogue. Should the victims have been heard? Yes, obviously, there's no doubt about it. But today, speaking at least for myself, the legal position as it stands is that the Supreme Court judgment remains untrammeled and unchallenged. Had there been a review, or had it been challenged, or had been questioned, things may have been different. But keeping in view the mandate of the Supreme Court 2022, it's a May 22 judgment, the Gujarat government was empowered to act in terms of its 92 policy, whatever it was, and the policy will have to see the light of the day. Of course, it is open to the victims to see whether what the policy is and whether there has been compliance with the policy. Because as I said, in the 2014 policy, there is a restriction and exercise of power of remission in cases of rape and gang rape and murder. But we don't know the content of the 92 policy. I would assume that it did not exist at that point of time, and therefore, to deal with the other point you said, therefore the 2022 guidelines of the centre would not apply, keeping in view the mandate of the May 22 Supreme Court decision.
Okay, interesting. But the fact is, Aman Lekhi, and I'll come to you, Vrinda. I know you're itching to get into it, but the fact is, no, just a minute. I'll come. Aman Lekhi, the fact is the victim was not even, her view is not taken. When this decision is taken by a government committee, the victim's family at least has told us we were not even consulted. Now the gang rapists will go back to the same village where the victim lies. How have you ensured any form of justice? Today, Bilkis Bano could well turn around and say, I haven't got justice. The people who killed my daughter, who killed my family, who gang raped me are coming back to the village.
Let's break it down, Rajdeep, this is important. You are using the expression life imprisonment. Admittedly, life imprisonment in 45 is supposed to mean the duration of a person's life. But section 45 has to be read with another section, that is 433A, which says that after 14 years actual imprisonment, notwithstanding the sentence being of life imprisonment, a party is entitled to apply for remission, which attracts 432. Now 432 goes to section 57, which helps compute the period of remission. When the matter comes to the Supreme Court, because the law permits remission to be considered, the application is considered by the government of Gujarat. You put this question whether the Supreme Court would override the Gujarat High Court judgment. Now the Supreme Court can override because it's an appeal. And the reason why the Supreme Court overrode Gujarat High Court judgment, because Gujarat High Court had said that the court appropriate to deal with the matter was Bombay and not Gujarat. What the Supreme Court said was, because the offence is committed in Gujarat, the government which is competent to decide, that is the appropriate government, is the government of Gujarat. Now the government of Gujarat decides in terms of the law which is laid down in 432. You pointed out that the victim is not heard, but insofar as the process is concerned, the process is governed by the procedure in 432, which sets out who is to be heard and how it is to be heard, and that goes with the remission policy.
So does the victim not have to be heard?
The remission policy in issue is the 1992 policy.
Sir, for our viewers, sir, our viewers will want to know.
Pardon?
Under the law, victim doesn't have to be heard?
Yes, yes. As far as the remission is concerned, the hearing will entail the judge, the body constituted in terms of the committee under 432, and the facts of the case and the entitlement of the person be considered remission. What's very important is that while 432 entitles the person to apply, it doesn't vest in the person a right to be considered.
Right.
Now the decision is of the government. There are two aspects to it. One, whether 432 would lie at all, because they're going on saying it's life imprisonment, mainly because it's life imprisonment, because it's not a special category of life imprisonment, which has come later. This is very significant because no one has talked about it. A special category of life imprisonment is where the imprisonment is without remission. Now that came in 2008 and was affirmed in 2016. The judgment in Bilkis Bano in Bombay High Court came in 2017. The 2017 judgment, notwithstanding the Supreme Court having declared the law that the punishment can be life without remission, chose mainly to uphold the trial court judgment of life simpliciter. Now life imprisonment simpliciter is different from life imprisonment without remission. Had it been life imprisonment without remission, this order would have been illegal. But because it is life imprisonment simpliciter, remission is permissible. And because remission is permissible, in terms of 432, it has been considered.
Okay, so you're saying,
insofar as the entitlement for consideration is concerned, that is there.
So you're saying the procedure has been followed. You're saying the procedure has been followed.
Is concerned, yes, as far as the procedure has been, there's no illegality in the procedure. There's nothing wrong with the Supreme Court judgment. It's one aspect of it. The other aspect is when the government decides the matter. The government decides the matter in 432. Now, the decision of the government is not final, because the decision of the government is subject to discipline of 14. That is, it has to be reasonable. That is, for all the factors you said, that look at the nature of the offence, look at the character of the individual, look at the consequences of this particular act, consider also factors releasing this person back into society,
Yes.
and then conclude whether it would be a reasonable exercise of discretion to so release. So it is one thing to say that the decision which has been exercised under 432 is falling foul of the parameters are relevant.
Yes.
But it's a completely different thing to say that merely because the imprisonment is life imprisonment, there could not have been remission. So we have to first understand what the law is and then impugn it on the basis which law permits. So there is no space for rhetoric or emotions here.
No,
because you have to go by the law as it stands.
Okay, Vrinda Grover, you want to respond? You cannot go by emotions. Yes, this is a heinous
I am
crime.
not going by emotion. Please do not subscribe emotions to me.
Okay,
Everybody
go ahead,
else sitting on this panel actually are death penalty votaries. They should be reviewing their emotions, not me. Let me come to the law. The question is, was the victim heard in May 22 by the Supreme Court of India?
One by one.
The order is before us.
Yes.
The victim's
I think
counsel,
that's really
the victim was
unfortunate.
given no notice. At that stage, the victim was not heard. One, it is not to be heard in the committee. What is the 1992 policy? Why should the 1992 policy not be available on in public domain? Surely there's a Right to Information Act. Section 4 of Right to Information obligates the state to put all such policies on its websites. That 1992 policy seems to be a secret document governing the lives of people. So I would really request the state of Gujarat to make available the 1992 policy so that we are all better informed. Thirdly, yes, I'm very grateful to Mr. Lekhi for pointing out that what is a decision sorry, before I come there, it is not only the state of Gujarat which is responsible here. Please look at section 435. Why are we eliding over this section? This crime was investigated by the CBI. Any investigation by the CBI, neither remission nor commutation, strictly reading the law under section 435 CRPC, no remission is possible unless consultation with the central government. So the central government has endorsed, approved, affirmed that this release and remission after 14 years of gang rape and mass murder convicts is okay in public policy. This is not a view only of state of Gujarat. It is confirmed and approved by the central government. That is the law of the land. Now let me come to Article 14. Yes, this decision is capable of being challenged and is subject to judicial review. A decision of April 2022 of the Supreme Court, Ramchandar versus State of Chhattisgarh. I'll read just a short bit. Why? And this is on remission. While a discretion vests with the government to suspend or remit the sentence, the executive power cannot be exercised arbitrarily. The prerogative of the executive is subject to the rule of law and fairness in state action embodied in Article 14 of the Constitution.
You're saying, therefore, this is subject to judicial review. You're saying, therefore...
Court has held that the power of remission cannot be exercised arbitrarily. Remission should be informed, fair and reasonable. I cannot think of a more discriminatory act by the state and central government than this release.
Therefore, Pinky Anand, do you believe Bilkis Anand, because she can perceive this as unreasonable, unfair to her, has the power of judicial review under Article 14, that even though the procedure seems to have been followed in a sense by the state government, the fact is if she, the victim, feels it's unfair, unreasonable, her rights under Article 14, she can challenge it, judicial review possible or not?
If indeed Article 14 is sustainable, it is not a matter of belief, it is a matter of sustaining such a belief by some cogent situation rather than to make statements. However, if Article 14 is violated at all times, any power exercise is always open to challenge. But a mere belief by itself cannot be the basis. If procedure has been followed, if there is no discrimination, if it is not arbitrary, if it is in accordance with policy, etc., I don't need to say more.
Does the nature of the crime, ma'am, matter? Ma'am, does the nature of the crime matter? The nature, the gravity of the offence?
I'm afraid, Rajdeep, I think this is a matter of state policy which defines where it can intervene and where it can't.
Right.
That itself cannot be the subject matter of any decision. And if you look at Sriharan, if you look at Ratan Singh, if you look at the subsequent judgment of Rajan, each of these judgments very categorically says it is undisputably the state government's prerogative to take a decision regarding remission. So you cannot possibly say or mandate, and the Supreme Court has time and again held, right from Sriharan's case, that you cannot mandate the state government in which manner to actually decide. So I'm afraid that is out of the domain. However, if procedure is not followed and there is discrimination and other issues, possibly that would be the subject matter of judicial.
You know, it's very interesting, Siddharth Luthra. Mohammad Feroz versus State of Madhya Pradesh, 19th April 2022.
I have to leave.
Okay, yes, you told me you had to leave early, but I appreciate that you've joined us. Mohammad Feroz versus State of Madhya Pradesh. Siddharth Luthra, the trial court had awarded a death sentence to Feroz, the accused of a 4-year-old girl. When the matter escalated to the Supreme Court, it confirmed his conviction but commutes the death sentence to life while quoting Oscar Wilde. The only difference between the saint and the sinner is that every saint has a past and every sinner has a future. Is this the Supreme Court in a way trying to ensure some form of restorative justice?
Sorry, I didn't hear the last line.
Is the Supreme Court trying to ensure some kind of a restorative justice, believing that whether it's in the case of Bilkis Bano or whether it's in the case of Mohammad Feroz, someone could, in a sense, reform over 15 years in jail?
I think the focus of your question is perhaps not entirely correct. Today, the Supreme Court has not passed any determination whether the sentence should be reduced or not reduced. All the Supreme Court did was go according to the Supreme Court, and that's the view they took in May 22. Gujarat is the appropriate state, go to Gujarat, and Gujarat will determine. So they left it to the government of Gujarat to determine under the policy whether victim should have been heard. Aman has made that point, whether CBI was the appropriate authority or not. But that judgment of the Supreme Court today is finalist unless reversed. This is a decision, an executive decision by the state government. That decision is capable of being impugned if it is arbitrary or otherwise contrary to the policy. So those are separate parameters. Today, we have to be very clear. What are we concerned with? We are concerned with the executive decision, and that is perhaps the subject matter of debate.
That's right.
When the Supreme Court decision came in May 22, from what I understand, there was no review filed. There was no curative filed. If there is no review and no curative, that is under Article 141, the law of the land. And that was very limited. It's a 3-page decision. Perhaps you may have seen it.
No, but
and it's only specific to remanding it to the Gujarat government.
That's right. So then let me come to where the crux lies, Aman Lekhi, is the role of the executive. Vrinda Goer says that this has been done in consultation, state and center. Now, the executive may have other compulsions to release someone. Even if the person is someone accused of, is convicted of as heinous a crime as gang rape and murder, a state government may, for political reasons, release someone. We've seen it with Tamil Nadu also in the Rajiv Gandhi assassination case. Therefore, I ask you, should the Supreme Court be re-looking at this or not? Should the Supreme remission, by leaving it to the executive, you're opening it to entirely political considerations?
Rajiv, please understand. I mean, we have to understand this, and I'll deal with this aspect. Sentencing is the judicial function. As far as remission is concerned, remission goes to execution. Execution keeps the sentence intact, and the law is that the execution is by the executive. In the scheme of things, therefore, once a sentence is passed, the ball goes into court of the executive. That's the scheme of the law. So, as far as remission or commutation is concerned, that is admittedly, in law, the role of the executive, over which the court has got absolutely no play.
But sir, there will be an element of arbitrariness in the executive.
Discharges its function. Yes, no, just a minute. Now, it cannot be assumed that because the executive is doing it, because it is within the domain of the executive so to do, it is arbitrary. However, if in the facts of a particular case it is found that the executive, in discharge of that responsibility which law admittedly vests in it, which is admittedly its responsibility because it's different from the judicial function of sentencing, certain consideration collateral to what is relevant has actually interfered and vitiated it, then that decision will be set aside. This law is settled, so you don't have to revisit anything. The law is in place. If, and as you are saying, if at any point of time, it is political consideration which motivates a decision, then a political consideration motivates a decision will make the decision fall foul of law, and if that is so, the decision will be set aside. So the protection is judicial review. You have to see whether the decision has been taken by the right authority and whether the right authority has taken the decision in the right manner.
So you're saying the protection lies with judicial review.
By the right authority, insofar as the procedure.
Protection lies with the power of judicial review.
You don't have to. The law is settled.
Okay, the law is settled. You're saying yes,
Absolutely.
Brinda. Brinda Grover, you want to respond to that because I'll come to you, Siddharth, in a moment because this case has political ramifications. I'm already reading out how political parties are viewing it. You're saying it has to be seen with a majoritarian mindset. There will be others who are saying, look, we've had cases in Kashmir where those who are accused or convicted of rape have got away. So it's a political minefield. Therefore, should such cases be seen in any differently?
Okay, so 2 quick points. I have always been against the death sentence, and I have been against remainder of life, natural life, long sentences. What is the argument I'm making here? Why is there a disquiet over this judgment? The law is no longer can be seen as a neutral field over here, because the state, which is meant to act on behalf of society and in a bipartisan way, is no longer conducting itself, and this is manifest in this case. The power of judicial review is a protection still to which this order can be subject. The disquiet is coming from the nature of the crime and the manner in which the state has usually been speaking. We were told that everybody in this country, including the state, believes in death penalty for rapists. Very recently, they were hanged. What is different over here? The difference lies in who the accused are, the nature of the crime, and the targeting. Now, if we want to talk about that, is where the disquiet lies.
Okay.
And I am saying, if the state acts in as a majoritarian penal state, we will have to recognize that this is signaling a certain kind of impunity. And if we don't, that is why the conversation about 435, which regretfully nobody is wanting to do here, that the central government has said this. What is the policy of the central government? That gang rapists and mass murderers should be released on bail, should be released on remission. That's the policy of the central government.
Let me
That's
get
not
both.
what I heard yesterday.
Let me get both Aman and Siddharth to respond to that, because Siddharth, you wanted to jump in first. You go first.
You see, I must clarify one thing, and as Aman said, political considerations. In fact, the Sriharan Constitution Bench judgment even refers to Maruram to say, there were cases where on a chief minister's birthday people were released. So those considerations, extraneous considerations to the principle of 432 to 435 CRPC, which are the provisions relating to remission and the policies of the state, are all, if extraneous considerations come in, the decision is vitiated, and once it is liable to be held to be vitiated, once it is challenged in an appropriate court. So if a decision is wrong in letting a person have premature release or remission, that decision is open to challenge. That's one part. However, having said that, and there was one thing which Brinda said earlier, which is interesting, which I must point out, is that the CBI having investigated, the question will arise whether the state was the appropriate government or the CBI was the appropriate government, and I'm not just talking about consultation. So if the centre is the appropriate government, then the judgment of the Supreme Court, which relies upon the Sriharan case, which deals with this, or the issue of, or even the aspect of consultation, because you can't have two appropriate governments. So then the point really will be, is the Supreme Court decision apt to challenge? And if it has not been challenged till now, then we can't say that the subsequent decision taken by the executive can be said to be contrary to the Supreme Court view.
Okay.
And that's what we'll need to test.
Can I get you in, Aman Lekhi, from an average viewer who's watching this program tonight? He will say, after the Nirbhaya case, everyone bayed for blood of the convicts and said death sentence. And eventually they were given death sentence and they said justice for Nirbhaya. Here is another case, gang rape and murder, not just of 1 or 2, 7 people. And the woman murdered. The woman gang raped, 7 people murdered. And here we are saying we must look at remission. Think of it, just a minute, man. The average viewer, Aman Lekhi, will want to know, how does the law operate? Is there an arbitrariness? Are we looking at how the public will respond when we decide on court judgments?
No.
No, first of all, Rajdeep, I think all of us here, Brinda is very agitated and repeatedly using the word majoritarian. That itself shows a preconceived notion as to how this is to be viewed, whether it's majoritarian or not. We go into the merits of the matter. And you can't start with the assumption of majoritarianism, because then that will vitiate your judgment itself, because it will show you are biased. But that's that apart. As far as 435 is concerned, 435, I mean, I don't agree with Siddharth that the appropriate government is not state of Gujarat, because when 435, read with 432, it's state of Gujarat only, it's correct, there's no other government to the appropriate government. All that 435 says, another thing which Brinda is talking about, consultation. That is, the state government can't do it on its own, it has to consult the central government. Now, the two governments consult doesn't necessarily mean it's a majoritarian decision. It may be a wrong decision, but it may not necessarily mean majoritarian decision, because you can't just typecast decision like that.
No, but answer the question. Answer my question. The viewers, answer the viewer's question.
Yes. Yes. Now, as far as this particular question is concerned, a lay person, as far as decisions are concerned, decisions are not going to be taken mainly because there is an opinion one way or the other, because then that will attract the very majoritarian argument which Brinda is condemning. As far as decisions are concerned, the decision will be strictly in accordance with law. That's why I said at the very beginning there are two aspects of it. One is the procedure, and that is a procedural aspect. The other is a substantive aspect. The issue you are raising is whether substantively the decision is wrong. Now, I will not get into majoritarian or otherwise. If the decision is giving a relief to a person not entitled in law, whatever the opinion of the public may be, that decision is wrong. So we have to go by what the decision is, and I personally feel in this particular case, whether the central government or the state government considered the gravity of the crime, because that's a very material consideration, the purposes will be the key, unless it is considered and factored. If it is considered and factored and for cause remission is granted, then the decision is unexceptionable. But if that is not considered and remission is granted, then the decision will be vitiated. Okay. We are not going to get into majoritarianism, minorities, religion, anything like that, because you can't bring these concepts, everything. The question is, does law permit it? The law will not permit it if the relevant circumstance, the issue which you have pointed out, has been disregarded.
Okay, I will still push for one final time. The distinction between a Nirbhaya and a Bilkis Bano. The distinction between a Nirbhaya and a Bilkis Bano, final word from you, Brinda Grover. Is that distinction a valid one or not?
I'm very encouraged by hearing Aman.
And I want to respond to that.
I assume that the doctrine of collective conscience will hopefully one day be purged from our jurisprudence, which has till now actually justified and rationalized death sentence and hanging. Yes, there is a difference between Bilkis Bano and Nirbhaya, and the difference lies in the completely arbitrary, biased, discriminatory approach in which the executive has conducted itself, and therefore, unfortunately, the identities of the women and the identities of the accused can no longer be removed and erased from the story. They are central to the story. Much as I would dislike it as a lawyer, I'm not going to be blind to this.
Just a minute.
Okay, yes, Siddharth, you have 30 seconds.
Where is the outrage?
Ma'am, you made your point.
Where is the outrage? Where is the
I just want to...
That's the point. Where is the outrage in this case?
I just want to respond.
Okay. And this is many rapes and many murders. Nobody asking for death penalty.
If I may...
Good.
Okay. Yes, Siddharth. 30 seconds.
Now, if I just want to clarify, Nirbhaya was a case where the death penalty was given by the trial court, affirmed by the High Court until the Supreme Court. In this case, the courts took a view to give life sentence, and that life sentence has gone up till the Supreme Court. Now, the point is, in a life sentence, there can be a remission to a lesser sentence, as pointed out by the speakers below me, and after 14 years that policy is to be determined whether it's a case which falls within the policy. In a death penalty case, it is normally reduced to life, sometimes for life till for a certain period.
Right.
Now so therefore the fact situation in the two cases was totally distinct, and having been the prosecutor in Nirbhaya, I can tell you that the courts took the collective conscience philosophy or the view that was taken by the Supreme Court was for the first time confirmed and elaborated in the Nirbhay case. That was not available at the time that the Bilkis Bano case took place, and the period of time therefore is a consideration in terms of the differential sentence that may have been given. Having said that, the fact today is we need to test the decision of the state government, and that is what has to be seen.